This is Barry Zalma speaking for Claim School Incorporated's blog Zalma on Insurance. Today we're going to speak about how not to commit arson and how an attempt to profit from arson failed. This is a fictionalized true crime story of insurance fraud. For me, from my experience and my practice of 55 years, explaining why insurance fraud is sometimes a heads-I-win, tails-you-lose situation for insurers, and why it takes skill to use arson to defraud an insurer. The case started because most people, including the arsonist in this case, do not understand how hard it is to set fire to a house that will destroy the entire dwelling and its contents. Most residences simply do not have sufficient combustibles in the right place to allow for a sustained fire. Many homes, especially the more modern ones, have fail-safe devices everywhere that make accidental fires a thing of the past. An insured decided that the only possible means of escaping his mortgage was to burn down his house. Being a rather imaginative fellow, he decided to also make the fire look like an accident. On leaving his house in the afternoon, he opened the gas jets on the stove, blew out the pilot on his gas dryer and water heater, and set the thermostat on his electronically ignited furnace to 80 degrees Fahrenheit. It was a hot summer day, but he assumed it would eventually cool off a little. The thermostat would kick on the furnace, and the electronic starter would cause a gas explosion that would destroy the entire house. What he did not count on was Southern California's Santa Ana winds that brought heat from the desert and kept the outside temperature in the hundreds all day and into the night. The insured was shocked that a nosy neighbor with a clear sinuses would smell the gas, turn it off at the meter, and save the house. Of course, when the insured returned home, he had to hide his disappointment that the house was still there. Undaunted, however, he tried again the next week. This time he took no chances. He went to the hardware store and bought a case of Coleman cooking fuel and spread it throughout the house. Then he tore up a book of paper matches so that there was no cover, only matches, and he lit a cigarette and placed it low between the matches and left the house confident that when the cigarette burned down, it would ignite the match heads and burn down the house. He was again sorely disappointed when he returned home to find the house still there. The would-be arsonist had his innocent wife with him as an alibi, and when they entered the house, she became hysterical at the sight of the flammable liquids poured throughout the house. She insisted that he report the incident to the fire department. He wouldn't do it, so she, against his wishes, called in the arson investigators. "Boy, you were lucky," a young fire arson investigator said. "The idiot who tried to set fire to your house set his fuse upside down." Immediately his partner kicked him in the shins, but it was too late to stop him. The fact that the cigarette to be used as a fuse must be placed at the head of the matches, not the base, was not known to the insured, and the cigarette merely burned itself out. The insured learned a lesson from the arson investigator. The house burned down almost totally 2 days later. The claim to the insurer included, among other things, one Encyclopedia Britannica and a wooden duck decoy. These inconsequential items, making up part of a claim for more than $100,000 in personal property, led to the insured's arrest when they were found intact and undamaged in his temporary residence, paid for, of course, by his insurance company. The insured was arrested for arson and insurance fraud, and his claim was eventually denied. He, of course, sued for bad faith, and the insurer was required to defend the lawsuit for a total of 5 years because it could not compel his testimony at deposition or trial until his criminal case was resolved. In the 5th year of the bad faith suit, the insured's lawyer called the insurer's lawyer and suggested his client would provide a release and dismiss the suit with prejudice for a payment of only $5,000. The adjuster in charge, although he had spent over $30,000 defending the suit, refused the settlement offer and instructed his lawyer to offer only $2,000, a minimal sum that would save more than $100,000 in attorney's fees and payments to the insured if the suit was lost. Following instructions, the insulting $2,000 offer was made, and much to the surprise of the defense lawyer, the offer was accepted. The suit finally settled with the arsonist and his presumably innocent spouse for a payment of $2,000, 20 times less than the amount expended by the insurer to defend the spurious lawsuit brought by the insured. Why did the insured offer to settle for so little? For at least 2 reasons. One, because the district attorney could not set a man free to try the arson case, and it was continued over and over again until all the witnesses were gone or had forgotten everything they knew. And 2, because the district attorney and the insured had made a deal that if the insured pleaded guilty to 1 count of insurance fraud, he would not go to jail. The district attorney, although he knew the insurer's interest in the case and the lawsuit pending against it, did not advise the insurer of the deal. Of course, had the insurer known that the insured was going to plead guilty to insurance fraud, they wouldn't have even paid the $2,000. They would have refused to pay anything. The case was never tried. 2 days after the settlement was paid in the civil action, and more than 5 years after the fire, the insured appeared in criminal court and pleaded guilty to 1 count of insurance fraud. He was given probation. The case wasn't a priority matter to the prosecutor, since only an insurance company was being hurt. The fact that the insurer was required to defend a bad faith lawsuit for 5 years at enormous cost was of no apparent concern to the prosecutors, nor was there any concern of the fact that the insurer was required to pay the insured's mortgage because the mortgage holder was innocent. The insured did not profit from the fire with a cash award. He was relieved of his mortgage debt, which the insurer was required to pay, and he paid his lawyer 1/3 of the $2,000 settlement. Since the insured was judgment-proof, the insurer lost as uncollectible the amount paid to the mortgagee, and taking an assignment of the mortgage, sold the bare land and recovered some of their money. Interestingly, the arson investigator who worked so hard to find evidence to arrest the insured was later arrested and convicted as a serial arsonist. Apparently, he was upset that there was an arson fire in his town that he did not set. He is now serving a life sentence in state and federal prisons, one following another. This video was adapted from my blog, Zalma on Insurance, and from my book, Insurance Fraud Costs Everyone, which is available as a Kindle book or a paperback from Amazon.com. The videos are available free from YouTube.com and from Rumble.com. And if you like the video, please click on the like button at YouTube and the thumbs up button on Rumble.com. And if this was of use to you and you're interested, please tell your friends and colleagues so that they can also subscribe to the blog and the videos. And if you wish further interesting and detailed information about insurance claims and insurance law, you might consider subscribing for a very small fee, Substack publications, or my locals community. Thank you for your attention.